Well, good afternoon. My name is Ala McCoy. I am Director of Startup Support at the University of Maryland's UM Ventures, and I would like to welcome everyone to our very first in this academic year installment of the Startup Fundamentals Workshop Series. Very happy to welcome everyone back to campus, either virtually or in person. So thank you for joining us today. We are recording this session, so if you would like to remain anonymous, you can submit your questions anonymously. So today's session will be focused on corporate and IP items that come up very commonly for any early stage startup. And I've invited today's speaker, very pleased to welcome today's speaker, Alexander Slafkosky, who is an attorney with Scale LLP. Alex provides strategic patent preparation and prosecution counseling to his clients and enjoys providing advice to early stage startups. I'm going to let Alex speak a little bit more about his experiences, but just before we begin, very quickly, during the session, please feel free to submit your questions using the Q&A function at the bottom of your screen. And again, you can submit your questions anonymously. We are recording the session. It will be posted on our Startup PMD YouTube channel. You can also raise your hand and I can unmute your microphone, but that's going to be at the end of the session if you would like to ask your question live as well. So again, thank you so much, Alex, and thank you to all of the live audience and those watching us on YouTube. I'm going to turn off my camera and my mic, and the stage is yours.
Yeah, thank you for the introduction, and thank you for everybody that's here. I'm going to try to screen share. Ala, I think you need to give me permission to screen share. It says host has disabled participant screen sharing. All right, now I'm co-host. Great, thank you.
You're welcome. You're now co-host. You can do whatever you want.
Awesome, thank you. Okay, well, yeah, I'll start. I always like to start these conversations with an introduction on my background. I'm a 2013 grad of the University of Maryland. I was aerospace engineering. In fact, I've collected a few different NASA themed things over the years. I graduated in 2013 from the University of Maryland. I was space track. I spent a number of semesters doing different design or research lab experiences. I always enjoyed the technical writing portions of my experiences while in undergrad. I didn't really enjoy the research parts. To those of you that do, great for you. It was not for me. I didn't know what to do with myself. And I talked to somebody I knew and they said, have you thought about being a patent lawyer? And if you know what patents are, good for you. You're better than I did because I got all the way to college before I even heard about what they were. Yeah, and I went straight from undergrad to law school. University of Maryland, Baltimore is where I graduated from law school. While in law school, I got my patent agent's registration. So that means you can represent people before the patent office. And then I also worked during law school as a law clerk / patent agent for a firm in DC, driving back and forth from Baltimore and DC during the week to do work as well. And while during law school and for the first few years of my practice, I represented large multinationals out of Asia and in Japan and Korea in particular, filing thousands of patent applications all over the world, helping them mostly on their US strategies, how to get patents granted in the US. And then I transitioned because I thought to myself, I should probably advise US clients because I'm a US attorney. And I then transitioned to a different firm and I worked for some of the largest US companies filing and getting their patent applications granted. I have experience in all the disciplines except for really more chemical or pharmaceutical grade. So mechanical, electrical, software. My aerospace degree comes in handy in all those areas. And each one takes a little bit different strategy-wise. And over all this time, I've also dabbled in other IP domains, copyrights, trademarks, et cetera. And then for the past year and a half, I've been at Scale LLP, which is a national virtual law firm. We have no office space in the country, and we operate on a pretty lean cost structure. And the idea is that I can choose who I work with, what I do, and as a part of that, I like to give back and help out at University of Maryland and help early stage companies figure out their corporate and IP strategies. So just a brief overview on the agenda slide here. I'm going to give you a very quick talk about what scale is, and then move right on to the things I think we all are interested in, which is corporate issues and strategy, basic issues that you're starting to start your own business. What does that take? And then I'm gonna end on a kind of a survey / issues of IP things that we can run through and keep an eye out for going forward. So as I said earlier, Scale is a national law firm. We have a lot more going on than just IP and corporate. We have a litigation team. I always like to say that I proudly do not go back to the courthouse. I've only been back once after I was sworn in. I don't want to do litigation. That's why we have people that do litigation for us. We have a whole real estate team. We have, fintech advisory services, a bunch of different areas, all doing very different practices. But the idea is that we can cover each area of a startup as it grows from early stage all the way to exit. So I guess the first question as a startup enterprise should be is, great. What does it even mean to have a company? A company is technically a legal individual, just like you and I are legal individuals, and it has its own personhood. Is the weird legal doctrines that we usually look at in corporate law. And as you see on the screen here, you see a bunch of different types. LLCs, C corps, LLPs, PLCs, DAOs, and then over in the far right-hand corner down there is the you, y'all, catch-all. Those are sole proprietorships. Anybody that just does business without some sort of entity is a sole proprietorship. And if you get together with somebody else, that would be a partnership. Those provide you no protections, no general legal protections versus the business enterprise versus yourself. So the way I like to explain this to people is that really ideally you sign a contract as an LLC or a C corp. The C corp or the LLC is the one responsible for that contract, not you individually as the owner of the business. Now that's just one example and a contract example, but you can think of many, many more examples of how that shield, that layer of protection, can be valuable to you. For instance, you sell a product, the LLC or the C corp might be liable for product's liability issues with that product. You sell a car that happens to catch on fire, you, the company, would be in trouble. Of course, you'd be in trouble because that product shouldn't catch on fire, but you as the stockholder wouldn't be in trouble. Now, there are some checklists to make sure you do to make sure that that stays true, right? You treat the entity as separate from yourself. You respect accounting. You respect where money's supposed to go. You do the proper corporate actions each year. You file the right things at the right times. You have yearly, if you run a C corporation, you run yearly board meetings because that's what the rules say you have to do. Generally speaking, I advise early stage companies to form an LLC, limited liability company. That's what an LLC stands for. It's just basically the special version of a C corporation. You have certain tax advantages when you run an LLC. It's treated like it's treated like a partnership under the tax laws by default, but you get standard corporate actions taken care of underneath the corporate laws. Two different regimes, tax law separate from corporate law. You can basically choose how you want to be taxed. Once you fall into one of the corporate regimes, you stay there. LLCs are nice because there's very little overhead required to run an LLC. You don't need to do board meetings every set period of time. You don't need all the structure of a corporate board. You don't need to have other things like a secretary that takes minutes. You can just do things underneath an operating agreement that says this managing member can do X, Y, and Z, and then the managing member can just go do that stuff. The rest of these on this slide are not going to be relevant to most startups. LLPs are just a limited liability partnership. It's the same as an LLC, basically. It just makes it easier for partnerships to have some protection. PLLC or a P Corp, that one's not on the slide, are professional service companies. You see that a lot with lawyers or dentist offices or engineering firms. The one that's not like these is a DAO. A DAO is just a cryptocurrency construct. There's been recent litigation around this. It's not really been settled yet, but in short, it's a collection. They may get LLC protections, they may not, based on what actual structures they've used. If you don't see a LLC or a C corp, I would assume that it's not giving you any liability protections. So that's a thing to look out for in life, especially if you're into the cryptocurrency space. But the shorthand of the question is be an LLC until somebody like an outside investor tells you you have to be a C corp. You don't want to pay the extra fees. Now, the second thing is, where do you file? The usual place to file is Delaware. You don't have to file in Delaware if you don't want to. You can file in California if you want to. I wouldn't advise you to. California costs a lot more money than Delaware. You could file in Maryland, because hopefully you all starting your enterprises in Maryland. And Maryland's relatively comparable to Delaware for filing fee purposes. And the rules are basically the same. Obviously, there are some changes, but not anything significant. And if you operate in Maryland anyway, you're going to have to register with Maryland anyway, because you're doing work in Maryland. Your business operates in Maryland. Even if you're a Delaware enterprise, you need to register as a foreign entity in the state of Maryland if you're going to run a place of business in the state of Maryland. These are the kind of questions that you will run across as you run a business and grow your business. The analogy I always use is, look around you. Every single service and function and activity you see at the University of Maryland, you will then have to do in your startup. You know, who's going to take care of this trash? Who's going to take care of the electricity bill? Who's going to run HR, right? So this is just one more part of every single feature you see around you. This is just the corporate structure. Okay, I'm going to use the C Corp as an example, but this is the first thing to think about as a startup. Early stage you will wear multiple different hats at any one time. You, as the startup in the company, the first founder, for instance, owns all of the stock. You will be the owner of the enterprise. So sometimes you will wear the stockholder hat on your head and make decisions as a stockholder. Sometimes, when you get a little farther down the road and people start making you follow all the rules, when you have a board of directors, the board of directors is who is in control of the enterprise. They take their instructions from the owners. Backwards, sorry. They take their instructions from the owners and they vote accordingly on the decisions about how to run the business. Directors have certain obligations to both their stockholders that have voted for them or given them their position, and in certain circumstances, to third parties. When you are a director, you have obligations to the stockholders and sometimes to those who you owe money to as the enterprise. So if you are bankrupt, you no longer have only duties to your stockholders. You now have duties to those that you owe money to. There is a whole regime of liability out there for directors, for actions you take and don't take. You can buy insurance for that. And then usually the person, the founder, would be the CEO or the CTO. You would be an executive position, right? Who is, actually doing the business day to day. They are the executive operations people, CEOs, right? They actually execute and handle the business. You, as the founder, will wear each of these hats every day doing different actions. You, as the CEO, will hire people. You will actually sign the contracts to hire people. You will have the authority to sign those contracts because you, the director, have decided the direction of the company should go in this direction. And then you, as the stockholder, have approved that idea, informally or formally. Early on, you're going to do this all the time as you do different corporate actions and do different things. Later on, you will have to more formally wear these hats as you do different things. I always say, eventually, you will probably sign a contract as an employee and as the CEO, and you might then sign a board consent as a director of the board that says, we approve this action. And then you might have to sign some, shareholder agreement that says, we, the shareholders, vote to authorize this action of the board, right? So you're going to wear many different hats. And the important thing is that this is just one part of respecting the corporate personhood of the C Corp. If you don't respect these rules of how to operate the business, they will treat the C Corp like it does not exist. And now you're back to being liable for everything that happens, which you would like to maintain. So you wear different hats, right? We all have different actions we take each day, and this is just an example of that in the corporate business world. There's lots of other ways in which you got to maintain your compliance, right? You got to pay your taxes. You got to, as I said earlier, you got to register yourself in different states with where you do business or where you have employees, or maybe you have to do some sort of contracting in a different state. Does that mean you need to file a foreign entity statement? Maybe you're like Amazon and you have warehouses in multiple states. Do you have to pay sales tax in that state? Right. So these are all questions you'll have to address. There are people that help you solve these questions. And that's what this entire list is basically, is things that you have to address, but maybe are not the core issues to your product. So state entity compliance is fairly straightforward. In most states, you have a yearly filing requirement. Basically, you file a report saying, here are the people that currently have membership interest, and that's a tax tracking issue, basically. These are people that should have tax liability or not have tax liability for us. We currently have these assets. These are our obligations to pay you for being an entity still. Each year, if you're a sole proprietor, if you are a single member LLC, taxes are pretty straightforward. You get to use the same tax forms. You just report the income or loss on your taxes, basically, as a business. If you have more than one owner, you will then have a multi-entity LLC filing with each state where each person resides, reporting basically their portion of taxable income. If you have a C Corp, you'll have multiple layers of taxation. You'll file a first tax return as a C Corp, and then you'll probably get paid a salary at this point. You'll have your own tax issues, right? To pay for your salary. If the C Corp issues you distributions or dividends, you'll have different types of tax issues, right? So each of these rules and the different structures is something for your accountant maybe to help you with, maybe me to help you with. Depends on which regime you're more interested in at any given time. Again, going back to the early stage question, is just be an LLC. It's a pass-through entity for tax purposes, gives you nice liability protection. You can address these questions later on as you get more value. Some larger entities, like institutional investors, will want to be a C Corp so that they can get certain long-term shareholder interests. You don't get those as membership units in an LLC, so they might make you convert over. Anyway, so the next couple of issues on this list are, catch-all issues. If you're doing a product or a startup that is software-based or healthcare-based or fintech-based, or EDU tech-based, data privacy, cybersecurity, and then the associated regimes underneath medtech, fintech, edtech. All of those have very complex rules around them. In short, be as good as you can be. Right? Hashtag, I'm not your lawyer right now. Be as good as you can be. No one's going to sue you over no value. But if you're Meta and you're in the EU, they're going to sue you over every single data privacy violation they can think of, as an example. Right? So there's a sliding scale issue. If you're like, yeah, of course, be compliant. In certain things, you just don't have the allocation and the bandwidth or even the value really to protect. So yeah, don't sell people's data because that's just an obvious liability for you right now. If it turns out that as you get somewhere closer to your Series A or B, and that is a portion of what you do, there are ways to ethically and properly compliantly sell users' data. So the safe way is to store data securely, don't sell people's data, tell them what you process their data. And if it's fintech or medtech, there are whole separate other rules about what you can do with data. Same thing with edtech. The one that's not like these is the HR issues. HR is usually state by state issues about how to structure employment contracts so that you're compliant with each state's employment laws. in most states, it's at will employment, so it's not that hard. But there are rules about, why you cannot fire somebody, right? So there are competent legal professionals to help you with each of these domains. Scale has plenty of them. I help people all the time in these areas. In short, these are all just compliance though. These are not core issues of your business unless you're fintech, medtech, edtech. So a basic legal-ish contract. We all sign contracts day in and day out. In fact, I'm sure if you opened Zoom today, you might have clicked the box that said, I agree to this change in terms. That's technically a modification of a contract, an agreement between two people. In the case of a Zoom analogy, you get access to this webinar, which is really cool technology, and you get this experience. And what do? They get you using their product and probably some user information about how you use their product. The standard rule of the internet probably applies everywhere we go, is that if you're not paying for it, you are the product. So your data is probably being used by Zoom in some capacity, right? We all know that. We don't like to think about it. But that's the agreement that you're signing to. I agree to use this service. You agree to give it to me. And as a part of that exchange, they get to do things with your data. Some of you might be accessing this via your UMD account. In that case, the agreement was between University of Maryland and Zoom. And the University of Maryland agreement, maybe via the state or directly with the university, might restrict the ways in which Zoom can use that data. In short, that's all just contracts. And you can put anything you want subject to certain limitations on what's legally allowed in contracts into a contract. Doesn't mean it saves you from liability anywhere else. But you guys basically, it's an agreement between two different people about what is the exchange for, one thing for another thing. In the case of the Zoom, it's access to a web hosting conference and video conferencing. In the case of like a sale of a product, I give you the product, you give me money, right? Really straightforward. Now, these can all get more and more complex, right? Like, what is an R&D or a contractor sales agreement for, right? For some milestones to be completed in return for these research tasks, we give you X money, right? So all of these kind of things are what we help startups address as they navigate the early stages. And obviously, as you get larger and more value, you have more and more of these issues. Contract negotiation, management, and tracking is just another part of general corporate governance and life for an entity. You're always going to have a bunch of contracts doing very different things, right? So I'm not going to dive too deep into IP types. In short, the Scale team approaches IP under a multifaceted approach, because usually, as you can see with these Venn diagrams, you're going to have overlapping regimes that help you protect very different parts of your IP strategy, right? So if you're going after government grants like SBIRs, that is not the high risk IP strategy usually, but there are ways to approach that from a dual use perspective, right? SBIR will protect you from government actions, usually via some sort of government data right use restrictions, right? Whereas that will not control the commercial enterprise space, right? So your SBIR data rights do not protect you from third parties copying your thing and selling it on the commercial marketplace. How do you do that? Well, you go look at trademarks or patents or copyrights or trade secrets, right? So there's ways in which to protect different regimes, the same thing via underneath different regimes to optimize a little bit of what your strategy overall is going to be. Some of these will be useful against third parties, irrespective of if they have any relationship with you or not. That's a patent issue. Some of these will protect you from people directly trying to access and steal your data. That's a trade secret issue. Some of these will protect you from somebody who sees your thing and copies it. That's a copyright issue. Some of these that could also be a trademark issue, right? They copy your brand. It's not your product per se, but it's your branding around your product that they copy. That's a trademark issue. Some of these things will be confidential data that the general rule of corporate espionage is frowned upon is true. It'll be easier to sue somebody underneath a contract than underneath the general corporate espionage rules in place in the United States. So it usually helps you with employees or people that have contracts with you and you can basically say, this is a confidentiality agreement, and it's almost in every single employment contract that I see. You agree to keep certain confidential information confidential. So all of these are parts of the IP domain, and we're going to look at them in depth later on. And I'm going to move a little faster because we're already at the 30-minute mark. So some first startup issues. All right. So this is after you've gotten your founders agreement in place with your co-founders. Basically, what that is like, we agree to split the ownership in this way and the revenues in this way, subject to future changes based on other ownership interests. Right. But in short, this is our partnership of how to start this company. I'm going to do X, you're going to do Y. And for each of these things and the IP we bring into it, we get this percentage of ownership and you get that percentage. That's a founders agreement. We help people negotiate those all the time. That's before the enterprise is formed. Usually, if you've already started your enterprise and you want to add somebody on as a co-founder, it's usually pretty doable unless you've gotten significant traction, and then you might have some tax complications that get in the way of it. In short, it's usually solvable, but the taxes might get a little complicated. The next thing after, and then so as the part of forming your enterprise, if you use legal counsel, or if you use you use Scale, myself, for instance, or if you go and use a Clerky or one of these auto service providers, right? Stripe has, I'm blanking on the name of it, their service where they basically go form your Delaware C Corp and give you an account with them right there, right then. As a part of that packet, you should get a confidential information and inventions assignment form. If you don't, it's not that hard. You can go find one online, or you can have me help you do it, or some other attorney help you do it. It's pretty early stages probably for your company. It's not that risky. Basically, in short, what it's going to do is going to, as I said earlier, with the confidentiality agreement, you agree to keep the LLC's information confidential. It's weird because you're also the director and the shareholder and the sole founder. So you also can decide what not to keep confidential, right? But that is what you're agreeing to. You agree to generally keep the information confidential. And as you decide to share things, again, because you're the executive and everybody else, you are the enterprise, basically. Not literally, but you are. You can decide what to announce publicly. Okay, that's a weird wrinkle in corporate issues, but not that hard to deal with. And then you also assign all of your IP, not just inventions. Usually it's copyrights, sometimes trade secrets, sometimes works, your trademark rights sometimes, especially if you did some pre-sales as yourself, you might want to assign some trademark rights over to the company when you start it. So this is usually pretty straightforward. It's a form, not much risk here. It's important because if you want to take outside dollars on, outside investors are going to want to see each key person, the whole co-founding team, any employees have signed this form. That's just one of the things on the checklist that they ask for, and you're gonna have to show them. And if you want to go raise money, you should, know what they're looking to, know what the things they're looking for are, and then have it ready. I work for startups all the time that have a data room that has all of the, answers to the checklist already provided for the venture capitalists, so that the venture capitalists can go, hey, give me this, and you go, hey, here's a data room that has all this information. It's already ready for you. It makes you look a little bit more polished and presented and ready to go. All right, fundraising and securities. I dabble in securities. I do things I feel comfortable with. That's like usually advisor agreements, safes, convertible debts. That one's a little fuzzy. I don't really like doing those. Anything that is a serious Series A or pre-series seed series, really is a pretty serious securities offering. We have plenty of really talented people at Scale that do these. The nuts and bolts of securities offerings are complicated. There's a lot of moving parts. The SEC likes to regulate this pretty tightly. The baseline rules are you can solicit people you already know for money for your startup. Ideally, they already have certain amount of income level or a certain amount of net value, right? So there are certain rules to follow, and we should look those up and take care of them, make sure you're correct. Yeah, again, not much risk. The SEC is not going to sue you over your mom and pop round, your friends and family round, because friend A was not technically so and so. But what you do is you have them a say. You give them a form that says, "I am an accredited investor," right? And that way, at least you can at least point to the form and say, "I didn't know James was not an accredited investor. He said he was," right? So that's what Securities Counsel does for you. They advise you and structure things so that you're safe. All right. You will probably take on some friends and family financing. That's usually how things start. If you don't, you can bootstrap yourself. That's pretty great. You keep more equity for yourself. Most people like to find advisors early on. Those are pretty straightforward. There are fairly standard percentages and rates and amount of effort that you should agree to. If you email me, I can share a link with you. There are people that gather this data and look at industry standards, right? Roughly speaking, it's like less than 10 hours a month of work over 4 years gets you 0.5%. If somebody's telling you that you should pay them 5K a month and give them 5% of the company, I would want to hear what they're giving you. They should know the most important customers and also every single investor that's good for this space, because that's an amazing advisory agreement. Pretty standard safes and convertible notes for pre-seed raising. They're standardized for a reason. No one wants to spend a ridiculous amount of money on attorney's time for less than $1 million of raised capital. If you're going to go to a TEDCO route, for instance, you may not even need to use me. You can just use TEDCO standard forms. Now, that's not protecting your interest. TEDCO is not always 100% looking out just for interest, right? Everybody has their own interest at heart. That's why you hire legal counsel to protect your interests. But pretty safe to use the standard forms. There are risks. If you're an LLC, you need to rewrite the standard form because it's designed for a Delaware C corp. That's not that bad. There are other things out there. I prefer safes over convertible debt only because it doesn't make you insolvent when you take on a convertible debt instrument. For those who don't know, convertible debt basically is a loan that you take from somebody else and you accrue interest on that loan. And as you draw it down, you're automatically insolvent, right? Because you've taken on a loan, you've spent some money, now you have less than the loan amount in your bank account. You're technically insolvent. That's a risk, but no one usually calls that because that's pretty destructive. But it makes the board an interesting animal because you're no longer only the board members for the shareholders. Now you're also should be looking out for that loan because we're insolvent, right? So there's wrinkles to all these things. But convertible debt, if you don't pay it off, converts into usually like a Series A preferred share on certain transactions. Usually it's the first fundraising. If it's an exit, it also gets converted, right? So it's a really interesting solution to how to fund your company early on. It's complicated. Reach out to us. We have specialists that do this day in and day out. I generally do not touch this stuff. Except for advisor agreements, really. And even then, I'll probably pass it off to somebody else because this is not my bread and butter. And I have people that have been doing this for a decade, and they can do it way faster than I can. The one thing I should tell you all is keep more of your equity than you think you want to keep, because every extra percent when you exit for 10, 20, $50 million is significant. And knowing exactly what you're giving away for somebody's dollars today is important to know exactly what you're giving somebody. Because the transaction, the contract is, I give you equity, you give me dollars today. So what are you giving them? You're giving them equity. Equity is very valuable to you in the future. So you got to know what you're giving them today. Yeah. An uncomfortable topic that no one wants to think about is if a co-founder leaves, what do you do? Hopefully it's on good terms. And speaking as a person who helps people clean these up all the time, really please get something in writing. Ideally you have a lawyer or you go find a release form online that does these kind of actions. It gives the stock back to the enterprise. It confirms IP ownership. It basically says to the extent we have any claims against each other, they're resolved hereby. again, if you take outside dollars, they're going to want to see, hey, why was John Wick on your cap table from 2001 to 2005? And he's not here. Where is John Wick? Well, here's a release. John went somewhere else. He decided to go do his own startup. He gave all the stock back to the company. He also confirmed that we own his IP from that time, and we agreed that we have settled all issues between us, right? So please document, at least document that somebody's leaving. If the name appears and then disappears, there'll be questions and you'll need then to explain yourself. And it's always easier prospectively to get things done and buttoned up before you move on with your life. So if it's a messy breakup, you won't get these documents signed, and there's a whole separate issue of how do you break up a company so that ownership and all the IP is handled correctly. The last startup issue I'm going to tackle today is you've probably heard of the idea that you need to make an 83B election within a certain number of days. COVID made the days, I think 90 days was the time frame. I think it's reverted back to its standard 30 days. So the rule is basically, if you get something as compensation, in this case, if you're an employee, you get a restricted stock or an option plan, right? That is income to you, whether today or in the future. Now, the usual rule of thumb is in the future when it actually vests. The usual vesting schedule is 4 years, 1 year cliff, right? So you could pay tax today, or you could pay tax in a year or in year 2 when it vests. So when your stock vests, that's when you have income. Now, in a year or two, the stock might be worth 10 times the amount it's worth today. Today, it might be worth pennies. Your tax liability will be less today if you take the tax hit now than in the future, because when it gets vested in a year or two, it might be worth 10, 100 times more. And that means your tax liability went up 10 to 100 times more. And you might get issued, I don't know, 250,000 units of stock. Well, if each one's worth one 10,000th of a dollar today, I would want to pay that tax liability today than in a couple of years when the stock is worth $1 and you might have a 250 tax bill, right? A $250,000 tax bill, which is what, maybe 20-30% on 250. So that's pricey. That got very expensive, right? $60,000 in tax liability just from vesting stock units. Oof. Okay, so what they let you do is they let you file an 83B election. Basically, that's what tells the IRS to tax you today on these speculative investment assets that you've received from your employment arrangement with your company. Okay, that's cool. You save some taxes. You take some risk with it, right? They may not ever accrue in value. And in that case, you would basically get a loss in the future when they don't have any value. Okay, that's okay. Probably better than the large tax bill. But I'm pointing this out really for the company. The company itself has to recognize that they're giving their employees value, and that means you need to do with employment withholding taxes on stock that you issue to company as compensation, right? So on a lot of these issues that you're going to see as you grow your business, there's multiple facets to the same issue, right? There's an employee side, there's an employer side. How do you structure this so that you are compliant on both ends of the spectrum? I'm going to go quickly through the IP strategy because, in short, like this chart shows you, there are overlapping regimes of protection. Something might be branded underneath trademarks and also protectable underneath copyrights. The way I think about that is, like, a good example is a logo. A logo can be protected underneath copyright as an artistic expression of whatever the idea of the logo is, right? A whale that you've drawn as your logo. It could also be a brand name or a brand image that is associated with your goods and services, right? So in that case, that logo is 2 different IP regimes. Same thing with patents. You might have a design patent that covers the GUI interface that the copyright also protects. So each regime has some overlap with the others. The one that's kind of by itself is trade secrets, because the idea there is keeping things confidential gives them value. So what is IP? IP is a catch-all phrase for non-tangible assets that your company has. We just did a brief overview of them right there. The idea is that in most jurisdictions, you have certain procedures to protect your IP. Copyright is, I'll go over this later, but copyright is given to you automatically upon creation of your thing. To enforce that copyright that's automatically given to you in federal court requires you to go get a registration for it. So it's a legal landmine because people don't know what they don't know. So my high level advice to everybody in the startup space is to have an IP checklist check-in every 6 months, every year, whatever the number is that you have for yourself, to go through a checklist and be like, do I have IP things that we did recently or things that are happening soon? Some things are you need to do act beforehand. Some of them you can fix after the fact. Some things like trade secrets you have to do beforehand, else you lose the trade secret protection. So they're valuable because you think of the entire marketplace. Think of Marvel's value as the Disney value is just copyrights and trademarks, basically. Yeah, they have some cool technology patents, I'm sure too, but it's mostly just copyright and brand. Think of all the value that the large tech companies have, right? Think of the value that the DoD contractors have, right? So some of this is one part protectionist, some of this is one part, moats, as Warren Buffett says, moats. And one part of this is signals to the marketplace, and one part of this is rewarding employees, right? So there are many reasons why you do different IP strategies. And as a startup advisor, we really want to align with that probably first one, which is the Warren Buffett moat idea, how to protect yourself. And a little bit of a secondary one of like, venture capitalists like to see these things. We should go do these things so that we can get money. The third one is IP is useful for exit value reasons, right? If you can increase your IP assets on your books, registrations, patents granted, pending patents even, you can then argue for different characterizations of your exit value. So there's many reasons to go after different IP assets. The one that we all kind of think about first is the moat retention, how to protect yourself. So let's start with copyright, because that's usually the easiest one for people to understand. Copyright protects works of authorship. The funny legal phrasing there is tangible medium of expression. So it's not just the fault of the book or the fault of the image, it's what you actually go do to make the image or the book, right? So you type out the book, it gets stored into the RAM. That is the tangible medium of expression for the book. When you paint the picture, the tangible medium is the canvas with the paint on it, right? It does not protect all these things. Like I said before, you get some overlap, right? So if you have a compilation of facts, you don't protect the facts themselves, you get the arrangement and the way in which you present the facts. There's been some recent change in the recent years to make copyright pretty stronger, I would say. Maybe it's a good way to say it. Stronger copyright protections. More things are subject to copyright protections than they were before. If you followed the Oracle or Google copyright litigation, that's an example of things that have gotten stronger for copyright protection. In short, a lot's protectable. It only protects you from people that copy from you, though. So it's copyright. It stops copiers who see your thing and copy it. Here's a list of examples of works of authorship. They're all pretty straightforward, as you can probably imagine. The interesting ones, usually for my clients, are a sculpture, quote, sculpture, could be a physical manufactured good, right? It could be the design of your hardware product. It could be the software in the literary work of software is the expression of your code base. So in short, everything has multiple layers of abstraction. You can probably find some aspect to copyright your future product protection in copyright. It may not be tremendously overbroad, but as I was just saying to one of my clients last week, The idea here is to have layers of protection so that if you have somebody who is copying you or trying to, trade on your company, you're going to want to have as many arrows in your quiver to see which one sticks and stops them. And copyright is a relatively low cost option to get it done. There are some wrinkles with copyright protection. There's a default rule for works made for hire. The usual owner is the person who makes the thing, who makes the work, right? In certain categories of endeavor, usually like in film or TV, the default rule is if you do this, it's works made for hire. If you're an employee that makes a work, it's usually owned by the company. That's also a work made for hire. Ideally, you also document it in the written agreement with the employees. And the biggest wrinkle here, and this is what I always catch with some of my companies, is if you hire somebody to do stuff for you, an independent contractor, that's anybody that gives you a service, basically, or anybody that you've contracted with to give you certain services, right? Help me design this product. They will own the copyright to the work they do for you, right? So this is ad agency. I think a better example is I hired a freelance software programmer to help write some code for me. Do I own the copyright in the code he makes? No, not unless you agreed to it in writing. So that's the kind of stuff you got to keep an eye out for. That's why there's legal landmines in this area. So one part of this presentation is to give you an idea of what to look out for. The value is pretty straightforward. It stops people from copying easily copyable things. They're relatively easily gotten. You get them right away once they're made. And to enforce them against others, it's pretty easy to get them protected at the Copyright Office. To sue somebody, you need to file first. To get statutory damages, you need to file first. So I said every 6 months, have an IP strategy check-in. What do you do during that check-in? You go, what have we made in the past 6 months that might be copyrightable? Should we file on it now? Are we getting that kind of traction? Yes or no? If you're not getting that kind of traction, then don't spend the money and time on registering for it now. If you think you might have something that has traction, maybe maybe you do it, or you come to me and say, Alex, how do you protect this thing? And this might be a part of that process, right? All right, moving on to the next domain is trademarks. I'm gonna go a little faster here. Trademarks, basically it protects source identification. It's acting as a source ID for a product or service. So brand names, Coca-Cola, Apple, etc., are all brand names we recognize. They all indicate the source of a certain product or good or service, right? You see the Coca-Cola symbol or the graphic for their logo, you know that they actually went and made this product, whether themselves or they licensed it out to somebody else to manufacture in Mexico, for instance. And they provided it to you, right? Via some channel of sales. But they are the source of this, so you know the quality and you know what you're getting, right? So that's what trademarks are protecting: source identification via some mark, which is the trademark term for a brand name or a logo or a tagline, for some good or service, right? You get state level protections underneath trademarks in each state you do business with that good or service and that mark. Those are not, they're not terrible, they're not nothing, but they're not federally protected. And what you want to do underneath the federal domain is at least file on your brand name or clear your brand name. Search out there, make sure you're not treading on somebody else's trademarks rights, right? Because there's no like innocent infringer defense. You can bring it up and it may mitigate other actions for you, but it's not going to protect you wholesale, right? You may get a court telling you, please stop using that, right? So there's a reason why to search for these things. But in short, the federal protection does a lot more than the state protection because you get nationwide priority to then continue using your brand with your goods and services. I help people all the time figure out what their trademark strategy should be. And this is an example of the range of things we want to protect. Over here on the far left is things that are strong, which are fanciful and arbitrary or suggestive. Apple's arbitrary with respect to computers. There are whole terms that are made up, right? Exxon for gasoline is a completely made up term. That's why it's fanciful. It was not a word before Exxon made it and used it as their brand name. On the other end of the spectrum, so those are all great things to have. fancy, arbitrary, suggestive. Great things to have for trademark protection. On the other end of the spectrum is descriptive and generic. And it's like descriptive is just telling people what you are already, right? Like apple farm that sells apples. We are a farm that grows apples and sells apples. Other apple farms have to use that description for their services. We can't tell them to stop using it. So you don't get a trademark on apple farm. I do this a lot. A lot of companies usually brand first on a descriptive basis and then add something suggestive after the fact. Ideally, you start there in the first place. All right, I'm going to quickly go over patents versus trade secrets because they kind of have a yin-yang relationship. The patent ideas, you get a exclusive period of time on functional things. Now that could be a ornamental feature and a design patent that's functional, or it could be the utility patent that's on the actual functional idea, right, itself. And why you get that exclusive period is because you give the patent office a pretty deep technical document explaining the full disclosure. That means what is your invention, how to make it, what do you do with it, what are the benefits of it, etc. The average cost for a design patent application is several $1,000s. I think on average I charge right now $2,000 per design application. For a full utility application, it can range from $8,000 to $15,000. So it's not nothing cost-wise and effort-wise. It's going to be 40, 60, 120 pages of work describing everything. But there's strong, you get a pretty strong exclusive right, especially if you align your patent claims with your product and make sure nobody else can come and do what you do too. It may not stop the Apples or Metas of the world from copying your technology because Apple's worth $2 trillion. If they want to copy you, they can copy you. And then they'll pay a license fee if they lose the lawsuit. But if they want to copy you, they can copy you, right? The patent does not stop them from copying you until a court says this is an injunction, stop it, right? So what do you get? Well, to get it, you got to satisfy all these things. Basically, a patent is for an invention. Invention has to be useful. That's pretty low threshold. The harder ones are novelty and non-obviousness. Novelty means strictly novel, meaning in one document, all of the features, or one product, all of the features of your claim are shown in this product or feature, or this document. Luckily, in the US, if you've already announced your product or done a sale, you have 1 year to file for a patent. Other countries, that's not true. In Europe, for instance, they have a strict novelty requirement, meaning if you have publicly disclosed or sold your product, you do not get a patent in Europe anymore. So ideally, you file before you do anything, like do a sale or you publicly announce your invention, right? The rest of these on the bottom of the sheet here, the non-obviousness, enablement, written description, some of these are just like about claims and how do you structure it. Some of these are fuzzy or just hard things to answer straight away. Non-obviousness. What does it mean to be non-obvious, right? How much of a step technology-wise do I have to give so that the examiner can't say my invention is obvious? That's a hard thing to answer because it's very context dependent. And that's one part of what a patent attorney like myself would help you figure out in the process of negotiating with an examiner. And we're almost at 1 o'clock. I'm going to go even faster. The value is pretty straightforward. You get a license fee basically, or damages, but basically damages are calculated at a license fee. You could get injunctions, especially if you were providing a product in a marketplace. And if they are aware of your patent, you can get some multiplier effects. It's how egregious their actions were. All right, so trade secrets. I'm just going to end on this because it's kind of the counter story to patents. Patents are about disclosing your technology in order to get an exclusive time. Trade secrets are about keeping things quiet, very quiet. No one knows what we do. We're not going to tell them what we do because we get an advantage from using this information in this way. Usually it's manufacturing techniques. It might be back-end server processes, etc. The question is, can somebody know what we're doing or not? If they can't, think about trade secrets. How do you protect them? Oh, sorry, it's not that. The trade secret value is that Coke has had a trade secret on the Coke for over 100 years, right? They can last forever as long as they are kept confidential. You lose it once it becomes public, though. Ooh, so there's a trade-off there. That's what you think about as you do patenting or not patenting with trade secrets. And how do you actually do the protection? Well, ideally, you actually label it and you actually put protections in place. That's what you really, really, really should do. Like with everything else in my life, if you want to sue somebody, you can sue somebody on trade secret. It'll be their job to point out that you didn't do the right steps to protect your trade secrets. So that's it on the speed run on the back end on IP issues. I'm sure we have questions, and I would love to. I don't have a hard time at 1 o'clock, so I can answer as many questions that you guys have today. And that's the end of the presentation. I see we already have one question in the Q&A section here.
Yes, thank you so much. So we do have first question. If other people have additional questions, you can either type them up, or you can also raise your hand and I can unmute your microphone. So do you want me to read the first question to you?
No, I can read. I'm reading. I was just reading. I can read it out loud for you guys. That's fine. An ADA compliant thing to do. 83B. What if you have no employees, not consultants, paid on a product-specific basis? Do you still need to file this now before any company revenue? Let me process the question, make sure I understand it. You don't have employees, you do have consultants, correct? And you paid the consultants on a specific product basis in stock. Well, that's a transaction that they will have taxable income on. Now, if it's vesting stock, so I guess it would be more of a I guess year payment for their contracted services would vest over time. I would need to look into if they have to make that election as a contractor versus employee. The employee-contractor relationship is a little different in that context. Sorry, Melva, if that's not a direct answer to your question. But in short, the company is not making the 83B election. The contractor is making the election. The company would only have to address the tax liability issue. And you would get notified of that by the contractor or the IRS, because then they would say, "Oh, you paid them this money," or they may not tell you, right? Because the IRS doesn't want you to take a deduction for an expense incurred this year. That's not their job. Okay, yeah, it's the contractor's responsibility. Same thing with the employee. It's the employee's responsibility to file the 83B election. As a good business owner and manager, you should tell your employees, though, when you get to employees. Okay, and Michael has a question. Shouldn't a prior search productive why file a patent application? Yeah, definitely don't file an application if it's already existing. One thing I didn't cover in the talk, besides for that 1-year deadline issue of filing after you disclose something, is you have options for low-cost options to get a filing date. Those are called provisional applications. They're only as good as how much effort you put into them. So I always like to say I used to do work for a very large Fortune 10 company. Every single patent application for them was a product. And they gave us 100 pages of documentation, business plans, technical white paper, et cetera. Those were really easy to handle because they wrote themselves. And the search on those cases were, could we get the scope we want, right? So a search is, you can pay a service provider $500, they'll give you a list of patents. You can read them if you want to. I don't know how useful it is. I worked for another large company. The searches were really only to catch like a dead on point reference. So like, yeah, you already got to the right answer, Michael. The idea is that you want to find something that tells you I shouldn't spend 10K on this. We don't know that until the search is done. I have some clients that don't do searches though. They're pretty confident. If you know your domain well enough, you could probably file a patent application because you know who's doing what in your domain, right? You know every single white paper, every single conference paper that covers X topic, right? You can probably find some way to characterize your advance in a way that'll get you a patent. Obviously, hashtag standard legal, not guaranteed outcomes, right? Let's see, next question. So unless you are a contractor, the idea you developed will be owned by the company, so there's any way to protect your idea or share it patent level while you work for the company. That is a question of what your invention assignments form says. Obviously, I can't advise you as to all possible permutations of that, because again, people write these things all the day, all the time, different ways. In certain states, there are limits. If you are a resident of California, for instance, now there's several other US states like this, but California is a good one for startups because that's usually where we think about things. Thank you, Silicon Valley. There's a rule that California basically said that if you are an employee, yes, the employment contract can assign your inventions to the company. However, they are not allowed to take your inventive ideas that were made off the clock and without company resources. So the short answer to your question is look at your agreement and see what it says. That may not end the analysis because there might be state level issues about what's allowed. And this is a U.S. analysis. If you're out of the country, each country has different rules about how inventing works. In some European countries, the inventor will always keep the invention, and then the company has to go through steps to get ownership of it. That might be a small check, right? So it depends on where you are, basically, is the follow-on question to it. Sorry, I just want to make sure I didn't leave anything on the table there. So it may be owned by them. If you share it, you may owe them an obligation, right? Because you might have violated your confidentiality agreement. This is an aspect of patenting that we all look into as I talk to companies, right? Like I talk to a new inventor and he's currently employed by somebody. I always ask the question, do you know what you've assigned to them already? Again, going back to what that contract says. Is it possible to form an agreement with the contractor that something produced by them under the agreement would become the IP of the company? Yes, certainly. In fact, that's a fairly standard thing we do. We do a bunch of DoD subcontracting analysis work, and the big Raytheons and big prime contractors love trying to say everything you do on this subcontract is owned by us, and we go, no. We're going to keep our IP. Thank you very much. We are open to you licensing some of this technology. Thank you very much. But yeah, you can definitely allocate. That's one thing so there's always, in most of these contracts, there's multiple levers involved. One is the economic interest, what lever, who's paying for what, right? Usually whoever pays for the action gets the IP. So if the government pays for your research, they usually get the IP. That's why SBIR is so nice. It's that they let you keep the IP. And in that case, you're an R&D contractor to the government, right? Whereas if you hire a third party to be your contractor to do something for you, you should start out with asking for the IP on that agreement. Sometimes it's not included, right? Because you use their template version, and their template doesn't assign the IP to you. Why would it do that? Right? So things to look out for, right? Because they might keep their inventions. Now, ideally, they don't do that because they should be repeat players to the same marketplace. And if you leave a bad comment on their IP policies, they may not be a repeat player. I don't see any more questions.
Well, thank you. Thank you so much also thank you for staying over time. This has been very informative and very interesting, and also demonstrates how many various different and important details there are in when you're thinking about what should I do, and then maybe things that people don't necessarily know that these issues or problems even exist, or even how to wrap their head around it. So
so I guess my very highest takeaway for everybody on the call is you probably didn't get half of that. But in short, remember, every 6 months to do a check-in, just a checklist of things to look at, right? Like every 6 months, hey, did we announce a new product recently? Okay, we're still within a window to file for patent protection, right? Or we announced a new brand name. Let's go make sure we're not infringing somebody else's brand, right? Ideally, you do all of these things prospectively, but I know how startups work. You need to execute your business, and then hopefully you can solve these things after the fact. So every 6 months, 9 months, a year, whatever it is, do a check-in. set it on your calendar so that it reminds you to do it, and then you actually do it. On the business side, you get some grace on certain actions. On some of these things, you really can't miss the deadlines. But usually, if you pay a fee, it's solvable on the corporate side. Usually, it's phrased as a penalty. Like you filed your yearly report to the state of Maryland late, they charge you a 1% fee for filing it late, right? So usually it's solvable, but ideally you're prospectively doing it correctly. But it's a long list of things, right? That's why just even being aware that these things exist is important to be ahead of the game.
Yeah, thank you. Great advice, Alex. Thank you so much, Alex, and thank you to everyone who attended and stayed until the very, very end. We will be posting this on our Startup PMD YouTube channel. I hope you will be able to also watch it there again if you want to rewatch it. And to those who missed the session, live session, will be able to watch the session there as well. So again, thank you so much, Alex, and thank you to all the attendees.
Thank you for having me.
Thanks. Bye-bye.